Good morning, everyone. We start a bit late this morning. There's two reasons. First of all, there are still delegates coming in. Secondly, we had a fantastic party yesterday evening. And I would like to thank on behalf of the Eden Community ERA for the invitation yesterday evening. I think it was a party with a lot of good talks that we had, either inside of the beach restaurant or at the beach. And I hope you had also the possibility this morning to have a walk at the beach, just to prepare yourself for a very interesting day that you have here in the second day of the Eden Conference. Just also for our Dutch colleagues in the room, you know that today is quite an important day for the Netherlands. It's the so-called Prinsjesdag, or Budget Day. So the king, on behalf, that is my understanding, on behalf of the government, declares the budget. And he does this in a very traditional way. This will take place today. Talking about budget, today we don't have t-shirts, but we have something else for the first one that is asking a question to the very, very interesting panels. And this is homemade, what we have for you. And this is actually the heraldic animal of the Data Protection Officers. This is a canary. So it was my colleague Jan de Sutter here in the first row, printed this 3D homemade. So for each of you that asked for the first question, you will get this heraldic animal and you will have the Eden logo underneath. So I wish you a very enjoyable day. If you now wonder why he's talking about canaries, just Google canary in the data mine and then you get all the explanation. I wish you a fantastic day. Matthias prepared with the colleagues together a great first panel. Enjoy. Thanks. Yeah.
Okay, good morning, everyone. I'm very happy to welcome you to the first panel here. The title is Data-Driven Investigation under the AI Act. And let's say before I will, no worries. Before I will start, let me make a little test. So, are you awake after the social event? I would say whoever is not. So, perfect. So, what I wanted to ask actually, whoever is not fresh and cheerful raises their arm. Okay, very good. As I expected, the majority seems to be fresh and also sharp. So that's very good. Yeah, my name is Matthias Robnik. I work as a legal engineer in Europol's data protection function. And I combine there my role as a lawyer and engineer and try to focus there on AI and also cybersecurity in our investigations, but also research and innovation projects. And yeah, as a moderator, I'm very thrilled to guide, let's say, our exploration into the AI Act and how it's, let's say, shaping the data-driven investigations. I'm also addressing key challenges and opportunities and also ensuring that, let's say, the AI technologies are used responsibly and also effectively in this very critical area. And we will also try to shine a light on this, let's say, exciting area from different perspectives. So on the one hand, the regulatory point of view, then the law enforcement point of view, and last but not least, the, let's say, a more academic point of view. Again, the housekeeping rules, we have, every speaker has 10 minutes. Less is even better because then the audience can ask more questions. And yeah, as I said, the speakers are very much eager to answer your questions. So please think about some challenging questions. Otherwise, it will be a bit like, let's say, upset. So without further ado, I would like to warmly welcome our first speaker, Jordanka Ivanova. She is a legal and policy officer in the UAI office in the European Commission and in the unit which is responsible for artificial intelligence regulation and compliance. And she's also a member of the legal team which has drafted the Commission proposal for the AI Act and also followed all the negotiations with the European Parliament and the Council for its, let's say, successful adoption. And also a little funny fact about her, she released to me, she's a mother of 2 naughty boys, and as such, she's experienced extreme events, let's say, and misbehaviors almost every day. And therefore, she said to me, she often feels like a little, let's say, law enforcement authority at home. And so that's why she's especially happy to be amongst us. So, Jolanta, the stage is yours.
Good morning, everyone. Very pleased to be here at this panel. And as said by Matthias, introduce you to just the basics of the Artificial Intelligence Act and our key objectives to promote the beneficial use of AI, but also make it in a responsible way so that we can ensure that it brings the benefits. And this is not my presentation, it's, I think, Alice, but I hope it can be changed. So quickly, well, maybe we do that. And because I just have 10 minutes, which I'll try to respect, maybe I start just recalling the basics of the AI Act. And that we design it as a product safety legislation applying to the AI system as such and trying to regulate as other products that these are safe, reliable, they achieve their objectives. But we also added an additional layer that we wanted really to address risks to fundamental rights and our European values to make sure that this technology is really shaped in line and contribute while actually also building trust in both users, deployers, but also the society as a whole when it is used. So yes, now you see it, and I hope I can switch. The next slide. Oops.
Just one. Are you doing so?
And this applies to all sectors because indeed AI is transformative. It has huge potential. And we aim to achieve that in every sector that it can be used, including in the law enforcement sector, that can also achieve these objectives, especially because in the law enforcement, we have particular concerns and particular implications for fundamental rights, for data, for bias, effective remedies, and the safeguards that must be there should also apply equally. So the objective was that we create with our common rules sort of a quality assurance and certification for AI systems that we can actually trust them and they are safely built, and that we bring legal certainty that is very important to both those that are producing these systems as well as those that are deploying them, but also citizens that would be affected by them. And through this, and with these very clear rules and procedures, how AI can be developed and used in a responsible way, we also aim to support innovation. Because without this, actually, we've seen that it could have the backlash and it would not actually build the trust and the objectives. And designing our framework, we've taken into account, of course, all the existing legislation, because we are not starting from scratch. It was mentioned, we have the law enforcement directive with clear data protection rules, we have criminal procedural rules, and we wanted to build something that is very proportionate also, and even if horizontal in scope, having specific tailored rules also applicable to specific cases where needed for the law enforcement areas. Oops, I'm sorry. And I hope here you could see the pyramid, but it's not clearly obvious all sections. But here you see the basics of our risk-based approach, which apply to all AI systems, as I said, but the majority of those are considered non-high risk because they already are regulated by the existing rules. And they could be subject just to voluntary additional requirements. We have the yellow layer with the transparency risks, where people had to be informed when interacting with AI or confronted with deep fakes. And the most relevant part is the orange area, where I'm sorry you don't actually see a bit more, because this is really the high-risk categories and area where data-driven investigations could be covered, and we have specific high-risk use cases in this area. For example, AI when used for emotion recognition, polygraphs, risk assessment of individuals based on, not solely based on profiling, but with also assessment of certain personality traits. There are also specific use cases in the migration area, when applications, for example, are assessed for their eligibility, remote biometric identification, that would be also considered high risk in all areas. And for those, there would be special rules with ex-ante requirements aiming to ensure that these applications, when they are built already in their design, the providers take into account transparency, data quality, non-discrimination, risk management, and assessment. They ensure accountability already before they are actually placed on the European market and provided to law enforcement authorities. And through these clear procedures, conformity assessments, there would be also additional rules for the deployers that would apply for law enforcement authorities when they use them. On the top of the pyramid, there would be also a certain area of prohibited, very limited AI practices. And we heard also yesterday, for example, this video of China mass surveying people, also creating social scoring systems, ensuring total control of the life of people, violating their rights. Here in the AI Act, those limited prohibited practices are precisely what we aim to avoid in Europe and make sure that AI is not misused for this kind of unacceptable practices and violation of our rights, and set clear red lines for this. And here there are some relevant prohibitions, including not to use real-time remote biometric identification in publicly accessible spaces for law enforcement purposes. Also, individual predictive policing solely based on profiling without any link to criminal activity, just by the algorithm predicting that we could be criminals. There is also the possibility for AI to be used for the untargeted scraping of images for creating biometric data sets like Clearview that we don't want in Europe and want also to clearly prohibit. And the unacceptable social scoring practices when people are just based on mass amount of data over time, judged and treated unfairly. So all this would be also prohibited in Europe. We don't want it. And there are still some exceptions, especially for the real-time remote biometric identification that was very heavily discussed during the negotiations. It was a challenging exercise in a way to find the right balance, still to think when AI could bring benefits and contribute to saving lives in some extreme cases, and prevent, for example, a terrorism attack that is imminent, or maybe help for the searching of kids. And with the AI Act, these very clear exceptions that are very limited only in 3 cases and subject to additional safeguards that should be further defined in national law could be only allowed when there is a clear balance and proportionality between the rights of the affected persons, and be very clear that this should not amount to any mass surveillance, but be very targeted, limited in personal, geographical scope to be allowed at all, and be subject to prior authorization by judicial authorities and very much additional safeguards, including all the requirements that would apply to high risk and fundamental rights impact assessment. And with this, we of course now try to set up with the AI Act that was successfully adopted and entered into force on the 1st of August. We tried to set up the implementing rules and a lot of additional measures that are still coming into place, because the laws can be perfect, but to be really effective, it matters how they are actually implemented in practice. And our approach was since the beginning that we are very practical. We create clear legal rules and also strong governance system with national competent authorities, but also setting European structures, including the AI office, of which I'm now part in the Commission, but also AI board with member states, independent scientific panel with advice, stakeholder engagements as well. We are also setting up all the detailed more rules that will help to operationalize the implementation, including for general purpose AI models that could be used to build those high-risk AI systems and other systems available on the market. We are also in the process of preparing harmonized standards for high-risk requirements for bias, data quality, cybersecurity, accuracy, actually, to give clarity to organizations what they have to do in practice. We are also preparing guidelines and implementing delegated acts on specific issues, including the guidelines, for example, for the prohibitions that now we have that are coming now into force in only 6 months after the entry into force in the 2nd of February, but also for the rules on high-risk AI systems, more detailed rules for specific high-risk classification, use cases, and targeted application of the requirements for different high-risk systems. And also we support the implementation of regulatory sandboxes. Just briefly to mention, with the AI office and also as the objective of the AI Act, we have now the twin objective, both to promote innovation, to enable the responsible development and use. So this is our twin mission, and that's why we also combine different units, including regulation and compliance, supervision of these general purpose AI models, but also research, and also promoting the international role and using AI, the AI Act as a good example to steer international also rules in this area. And also we are building the board with specific groups on the prohibitions and law enforcement that will further combine experts from member states and support us to get input for the development of these implementing rules, and will have important role for the consistent implementation. And also we'll have also soon the advisory forum next year, which will also include representation of all stakeholders, including academia, civil society, which perspective will be very important for us. So with this, I'll stop, and I'll be happy to reply to further questions, and also looking forward to the debate.
Perfect. Thanks a lot. You perfectly set the scene. So it was very interesting also to give a brief overview of the AI Act. I think it's quite hard because it's a big law with a lot of information in it, and really to, let's say, stick to the 10 minutes and then also emphasizing on some important points, that's not easy. Thanks also for emphasizing the harmonized approach, also in terms of ensuring trustworthy AI through the risk-based approach. And also, it was also good to see a bit like the role of the AI office. And then also, when we go later in the discussion, I think there will be definitely questions also related to the real-time remote biometric identification, and also, let's say, the exceptions and also limitations in how far, for example, law enforcement can use it, which I'm sure people are interested here. But we will go then later into this discussion. And now I would like to promptly welcome our next speaker on stage. His name is Damianos Chronakis. Damianos is an expert in AI governance and biometrics, currently serving at the Information Management Unit at Europol. His career began in 2003 with the Hellenic Police, where he specialized in counterterrorism, aviation, and also security. and information management. And since he joined Europol in 2017, he has been leading the implementation of biometric identification systems or technologies within the organization. So Damianos, please go ahead.
Good morning, everybody. Thank you, Matthias, for the introduction. It's an honor and pleasure to be here today at the Eden event to discuss such a crucial topic. As some of you, I spent the last 3 years of my life trying to understand the AI Act, actually, and try to understand the complexities that it brings to our work. And every time I hear a colleague from the Commission, I think we're getting a bit more wiser, actually. It will take some time. So today I wanted to discuss the complexities of AI and its role in modern policing. And of course, it's essential also to explore both the opportunities and the challenges that this technology brings to law enforcement, and of course, the impact that the AI Act will bring on our work. Okay. So we all agree that AI has already begun to revolutionize the way we approach criminal investigations. The ability of AI to navigate through vast amounts of data, identify patterns, and generate actionable insights is transformative. In areas such as predictive policing, for example, AI helps us anticipate criminal activity, allowing us to allocate resources more effectively, and in some cases prevent crimes before these crimes occur. Moreover, AI tools can detect anomalies in data and uncover connections that otherwise would have been impossible to identify manually. For example, in financial crimes, AI can quickly and efficiently flag suspicious transactions, help us identify and dismantle complex networks of criminal activity. Furthermore, AI systems can process unstructured OSINT data we have collected from open sources, to provide real-time insights, enhance our responses in urgent situations such as in crimes against children or during terrorist attacks. Moreover, technologies such as machine translation are essential to facilitate international cooperation among law enforcement. Such systems Europol have already integrated in our tools to help coordinate with our stakeholders. Finally, applications such as biometrics and computer vision have also enhanced our capabilities in identifying and tracking criminals. These tools have proven invaluable in the fight against terrorism, human trafficking, and as well as other forms of crime, organized crime, where rapid identification is essential. However, the adoption of AI comes with its challenges. One of the most significant concerns is the issue of data bias and fairness. AI systems are only as good as data, as the data that are trained on, and if the data contain biases, whether related to race, gender, or other socioeconomic status, these biases can only be amplified in the AI-driven decision. So this is particularly concerning the context of predictive policing, for example, where biased predictions can lead to over-policing in certain communities and even perpetuate existing inequalities and biases. Moreover, privacy and surveillance are also major concerns. The use of AI for law enforcement systems such as face recognition and other biometric applications, they raise important questions about the balance between security and individual privacy. And as we expand the use of AI, we must ensure that these technologies are applied responsibly, ethically, and within the limits of the law, that our practices are transparent and there are robust accountability mechanisms in place such as to protect the rights of individuals. Another challenge is the complexity of AI systems themselves. The so-called black box problem, I'm sure that you're all aware of this term, where AI systems make decisions in ways that are not always easy to be explained, even to those who actually have developed the systems. And in criminal investigations where AI-generated evidence might be used in court, it is important that we can explain and justify the decisions made by these systems in order to maintain public trust and uphold the principles of justice. Despite these challenges, the opportunities presented by AI for law enforcement are immense. However, to fully realize these opportunities, we must navigate the recently introduced regulatory landscape carefully. And of course, the AI Act, as we all be aware, is the most important regulatory framework in the AI in the world, and will have a profound effect on how we use AI in criminal investigations. And as we heard from Jordana before, the AI Act categorizes systems into different risk levels, with law enforcement applications often falling into the high risk category. That means that our AI systems will be subject to strict requirements regarding transparency, fairness, and accountability. Certain applications, such as the use of real-time biometrics in public space, as Jordana said before, will be subject of strict prohibitions. Predictive policing, individual predictive policing also might fall in the prohibited category, although some certain narrow exceptions for law enforcement were foreseen. In turn, that means that we need to reassess many of our existing AI tools and potentially deactivate, stop using those who did not meet these new standards. This could present significant operational challenges, particularly if we are forced to discontinue tools that have become integral to our investigative processes. At this point, I want to highlight Europol's effort to support our stakeholders, our law enforcement community, to assess compliance with the AI Act of the AI systems. We have developed jointly with our academic partners CC4AI, our compliance assessment tool for the AI Act, to allow users to evaluate whether existing or future applications meet the criteria set by the AI Act. The tool, which has been developed also in cooperation with other law enforcement agencies and the network of the Justice and Home Affairs agencies, is offered freely to affiliated organizations and became operational yesterday, in fact. On the other hand, I want to highlight that the AI Act promotes innovation through mechanisms such as regulatory sandboxes. These control environments allow us to test and refine new AI tools before these tools are fully developed, ensuring that they meet both operational needs and regulatory requirements. This is an opportunity for law enforcement to collaborate more closely with AI developers, academia, and policymakers to create AI systems that are not only effective, but also ethical and compliant. Again, Europol is called to play an important role in that regard, given its central role as a facilitator of police cooperation in the EU. So to conclude, we all agree that AI offers tremendous potential for enhancing our criminal investigation capabilities, but also presents significant challenges that we must address head-on. As we move forward with the implementation of the AI Act, it is critical that we strike a balance between leveraging AI benefits and mitigating its risks. This will require close collaboration between law enforcement, the AI office, of course, the academic community, and other stakeholders to ensure that law enforcement will develop and use AI systems that are fair, transparent, and accountable. It is also imperative that the law enforcement engage with the public to raise awareness on the importance of such technologies for modern policing, as to develop mutual trust and acceptance. Lastly, I would like to invite you all to read our latest report, AI in Policing, that was published last week. In the report, which was coordinated by the Information Management Unit, we dive into the intricacies of AI for law enforcement operations, its benefits and challenges, and we propose concrete steps on how to facilitate the adoption of AI by law enforcement. You can scan the QR code, or you can find the paper on our website. Thank you for your time.
Yeah, Damianos, thanks a lot also for your perspective. I think it was very good also to see a bit like the law enforcement point of view, also showing a bit, let's say, the transformative approach of AI, but also, let's say, focusing or addressing challenges like data bias, explainability in terms of black boxes, but also transparency. And I mean, of course, I'm the moderator, but I'm also a bit biased since I'm working here. I also want to highlight that even though the AI Act is now in place, I mean, we already deploy machine learning tools in operations. And also here, I want to highlight, since there are also colleagues from the EDPS in the room, that we had quite a long consultation process over 2.5 years, where we really pioneered, let's say, data protection by design and also AI governance. It was like a lot of work. But from this perspective, I would also say that, let's say, in the area of criminal analytics, Europol has definitely is in a good position. This does not mean that we need to adapt things, that we also need to, let's say, advance things, try to make every time things better. But I think this is also worth mentioning. And also the second point I really want to say is the compliance check. I think this is also very interesting, especially for, let's say, national law enforcement agencies, that they can play a bit around and look. There's also data protection in it. So it's really a quite comprehensive compliance checker, and it gives you a first glance assessment, which will also help you then further, let's say, if you want to make a data protection impact assessment or you need further compliance reports. Okay, and then last but not least, I would like to warmly welcome Radina Stoikova. We're very happy that we have you also on board. You're a leading researcher and assistant professor at the University of Groningen and also at the Norwegian University of Science and Technology. I saw you have numerous publications in estimated journals like the Computer Law and Security Review, and also the Forensic Science International Digital Investigation. And I also know that you had one notable work or publication in the relation, or let's say in the context of ethical and the legal dimensions of hacking within the framework of lawful investigation, particularly focusing on EncroChat, which I was also referring before. So there might be also some interesting, let's say, points to discuss. And then also, of course, I asked her for some interesting insights about her, and she told me that she did a 100-kilometer trail trekking in the Alps without any preparation. Wow. And then that you actually like Groningen's mustard soup, and you're collecting ChatGPT failures and memes. Very interesting. So as you can see here, we not only have very smart, but also very fit people on the panel. That's very good. Yeah, with that, Adi, please present your insights.
Thank you, Matthias. As you said, my perspective on the AI Act is in the context of digital investigations and forensics, which is the discipline that examines digital evidence from different devices like computers, mobile phones, audio and video recordings. And I want to make three more practical points. First, AI is just a tool. For example, computer vision becomes better at identifying objects of interest for the investigation. Detecting drugs, missing cars, guns is very useful for the police. And if such a system is used only for detecting certain objects, can be considered low risk, for example. But if you use it for with human prompts, for example, to find the suspect's locations in the video or a suspect's escape path from the crime scene, then this will be considered profiling and therefore high risk. What I want to emphasize is that this object detection system have no idea about what is a person. They will identify it as any other object. So the same system can be used for low and high risk tasks. So my first takeaway is that the successful implementation of the AI Act in law enforcement will depend not only on system design, but also on procedural practices. For example, who has access to the system, when is someone authorized to make human prompts, and what kind of oversight we can implement to ensure that the system is used correctly. Let's imagine that we don't want to use the system for human detection. Researchers try to anonymize faces in big data sets by blurring them or pixelizing them. And also in my own research, we tried to train the algorithm on a data set without any humans in it. However, in both studies, after deploying the model to another data set, the model was still able to recognize persons as objects, and more importantly, was able to re-identify the same person across the data set. In this sense, AI might challenge and render inefficient some of our data protection by design and by default measures. And the AI Act doesn't focus much on new forms of surveillance like non-biometric re-identification of people with AI. So it will be crucial to interpret data protection by design and by default in this new context, and more importantly, to understand who is responsible to implement such measures. Let's now take one low-risk system that is strictly for procedural tasks. Police has to do very cumbersome transcription of investigative interviews. It is estimated that 1 hour of audio takes 11 to 13 hours of transcription work. So we can automate this task with automated speech recognition. It's very useful. But even implementing of such a low-risk system in law enforcement can raise some important questions. For example, such systems tend to hallucinate statements that the person never said, which requires a robust procedure to ensure that the AI transcription is accurate. In addition, the interviewee might need options to cross-examine and challenge inaccurate statements. Discrimination issues might also arise when the system doesn't perform equally across demographics. For example, it transcribes people with accents or people who are non-native speaker poorly. So my point is that even low-risk AI systems might require changes in criminal procedure and additional human rights safeguard to accommodate issues of automation. Another important area where AI can be very useful is when you have very big data sets, big data cases, and AI enables searches for criminal activity in much more robust way. However, I want to look at this just from the perspective of a defense lawyer or a suspect. Scandals in Denmark and in Britain showed that even small errors in regular IT systems might cause quite significant miscarriages of justice at scale. Even an impressive investigation like EncroChat raised the question, can we ensure the principle of fair trial? Unclear scope and nature of the operation, experimental tools kept secret, inconsistencies in data sets, and lack of access to raw data was some of the issues that digital forensic examiner, defense lawyers had to deal with challenging EncroChat evidence. In AI context, I think this will be only amplified, this effect. In other words, we need to not only focus on the AI system itself, but how to transpose the principle of fair trial to this to AI-generated evidence. We need to move from trial-centric and jurisdiction-specific rules and move towards individual rights in concrete investigative procedures. In other words, we have to reconsider active digital defense rights tailored for AI systems. You can automate, but it should hold in court. This is not just a law enforcement issue. So a lot of commercial vendors supply law enforcement with AI tools. In this US study showed that police used commercial face recognition tools, although validation studies showed that they perform quite poorly. And the AI Act is ambiguous on the questions of repurposing and reusing commercial AI models or data sets for law enforcement tasks. The question is, can law enforcement use commercial tools? To what extent they are able to validate them? And will they have sufficient validation data sets, sufficiently large data sets to validate them? And to what extent commercial vendors will provide sufficient information for that? Here, I see a legislative gap, because I think commercial vendors who target law enforcement sector must have stricter regulation and even to be held liable in case their tools produce harms. Finally, the AI Act introduces a standardization regime, which is a bit problematic. In my view, it's best described with the Dutch saying, "De slachter koelt zijn eigen vlees," or "the butcher inspects his own meat." A lot of the implementation and enforcement of the AI Act is left to standards, codes of practice, and codes of conduct. This in itself is very good, because it allows innovation and industry-driven standards. However, the idea of self-assessments is that industry participates in the development of the standards, and then they self-assess if they comply with their own standard. In addition, I have to emphasize also that in a lot of digital forensic domains like vehicle forensics, we still try to figure out reliability standards on reliable acquisition and examination. And it is about to be researched and tested if digital forensic standards can be also applied to AI tools, or we need completely new approach there. The holistic approach of regulating the AI system from a legal point of view is very important, but I want to also emphasize the technical side. So constructing an AI model includes several very clear processes, important processes, and they might require specific standards or might be not susceptible to standardization. For example, pre-processing for input is one of the most cumbersome tasks. It's around 60% of the time and resources to build a model. And in the same time, it's very case-specific and very difficult to standardize. And finally, general purpose AI, like ChatGPT, they're subject mostly to transparency and explainability requirements. This is very great because those systems tend to hallucinate and deal very bad with noisy data. You can get anything from being scared that there is a tiger in a parking lot to losing lawyers practicing license. Interestingly, the legislator decided to have a computational threshold regarding the risk of GPAI. So the higher the computations, the more risky the system is considered. However, in my own research, we realized that implementing measures for legal compliance in the model increases the computations as well, which is the opposite of what actually was foreseen. So these are my 3 points, and I'll be very happy to hear your practical perspective and the needs of law enforcement in this context. Thank you.
Adi, thanks a lot. I really liked the presentation a lot. You touched upon a lot of different aspects. So first of all, thanks for the practical examples you mentioned, in terms of like high-risk AI systems, but also low-risk AI systems, the importance of the human in the loop, also the problems with re-identification aspects, and then also mentioning demographics when using audio systems, and also the pipeline, as you mentioned now, the machine learning pipeline, where again, I see that we have quite a robust process in place at Europol. And then also the important aspect with ChatGPT and hallucinations, but it's also getting better and better. Now we saw also with the new update of the last version, it's quite interesting. So it's really, and it also makes then a big difference if you have like the, let's say the free version or the paid one. So it's also, at least when you play around with it. And then also a very important aspect you mentioned is like, I mean, it's a bit geeky. I do not want to touch too long upon it, but the fair trial, and also there is also a case at the European Court of Justice, or was decided on 13th of April 2024, which was exactly to the EncroChat case and the fair trial. And I mean, in general, there are also still some cases going on. And also, if you're interested, we also launched a report. It's the first report about encryption, and there are also all the cases mentioned in the report. But maybe just also for the further discussion, I just want to highlight 4 points of the case, because I think it's important. And also the European Court of Justice said, first of all, public prosecution and also authority about it. That is, the ICJ confirmed that a public prosecutor can issue a European investigation order for the transmission of already gathered data, such as EncroChat data, for example, from another member state. This was the first point. The second point, which the ICJ also said, that substantive conditions from a European investigation order, so we need to have the same condition as the domestic conditions, meaning so the conditions for issuing, let's say, an European investigation order for evidence transmission must align with those of similar evidence in domestic cases. So what does it mean? It means, for example, if you gather the data in France, there needs to be the same legal standard, which is like based in a national procedural criminal law, because like it's always in the domestic member state, so they decide how, let's say, the structure of the domestic procedural criminal law needs to be, let's say, deployed. But it's important that let's say the European investigation order is similar to the national law, the national procedural law. And it also, of course, needs to be compliant with fundamental rights when an European investigation order is challenged. Then the third point was also the interception of telecommunications, where they said interception of telecommunications includes also measures like infiltration, terminal devices of data collection, such as measures should be notified to the authority in the member state where the interception takes place, and also ensuring respect for sovereignty and rights, which is very important. And then the fourth point was about like the exclusion of evidence and also a breach of EU law, where the court clearly said evidence obtained through an European investigation order that breaches EU law may be excluded if it impacts the fairness of the trial, or if the defendant cannot review or comment on the crucial information, which is also very important. So just to highlight these points, we are also aware of that. I think it's also interesting discussion, and thanks again that you bring this up. And this is exactly also what we want with this panel, that we have different views and that we can discuss these things. And yeah, now I'm very much happy to open the stage. Perfect. We have already, the first was Joe, he was very fast. Then Tony, and then here, I mean, so please, yeah, the bird is for Joe. It will fly to you.
So yes, thank you very much for the floor. Congratulations to all the speakers, and perhaps especially to Wadi, whose presentation I enjoyed greatly. And congratulations to everybody, not only on the panel, but to everybody else in the room who may have contributed somehow to the AI Act. Now that was the good part. For the part which is about the crap and the bullshit, spoiler alert, you can come to my keynote speech this evening, but there are a couple of things I'd like to say now. Firstly, I'm going to make something which I very rarely do, and I'm going to make some predictions. And for the non-Europeans in the room, or for those of you who are not lawyers, I should mention something which people often forget, that we're talking about the EU AI Act, but that some of the most important actors using AI in this context are not covered by it. Let's remember that under Article 4, subsection 2 of the Treaty of the European Union, national security and defense are excluded from the competence of the European Union. So let me make a few predictions. Because of that case, because of that, the police organization, which will be under most scrutiny and which will have its AI use most impacted, will not be the Dutch police or the French police, but it will be Europol, because it has EDPS. And unlike the other police forces, there is no national interest, and there is no police chief going to bug the ministers concerned. My prediction, therefore, is this. Prediction 1. There are going to be many more exceptions in national law than the drafters of the AI Act ever told anybody else. Prediction 2. You are going to see many, many cases of domestic law bringing in multiple exceptions for uses by national security and defense. And let us remember how difficult it is at this moment in time to legislate at the pan-European level. Take the Netherlands. We're in the Netherlands. Who does the border force in the Netherlands report to? It is part of the Ministry of Defense. So a border agency in the Netherlands is not technically a law enforcement agency. So the way they can use AI is not going to be regulated in the same way as, say, the police in Malta, where the border agency is technically a law enforcement agency. I could go on for quite some time, but I think we've got to be realistic about the way that things are going to go forward. The AI office has got an enormously important task and an enormously difficult task. Good luck. Let's remember some of the problems we're going to see with the implementation of the fundamental rights impact assessment and the reality behind that. I don't wish to rain on anybody's parade, as I said, but I think we've got to be very realistic in managing expectations and also in helping out. And I'd be delighted, if we could come back to Eden in a year or 3, look back on the AI Act and say, please, please, Joe was wrong on that day. But if I was right, another canary would be nice. Thank you.
Thanks for this comment, Joe. Does any one of you want to say something about it, or please?
Maybe I can start. First of all, really thank you.
Oh, perfect. Yeah, you can
Yeah,
just
really thanking about this reminder and frank advice, because we fully agree with you that a lot is just ahead of us, and all the implementation will clinch on both how we as EU institutions oversee and can help, but also how member states and also how actors behave on the ground. And there will be a lot of challenges, I think, as with every legislation. But what would be really important is that in the end, from my perspective, and just recalling some of the points that you mentioned, that indeed the national security exceptions being explicitly included in the AI Act still set some limits there. And member states, if they go beyond those limits in their national law, if they go beyond the exclusive use of AI systems for other purposes that are not just law enforcement, then this is clearly in violation of the AI Act. And then it will be, yes, for us, a lot on the EU AI office, but I think from all of you also as a society, as stakeholders, bringing also those cases at national level, bringing those points to the attention also of the competent authorities in courts, and then really trying collectively to uphold the implementation of this. And then another point just on border security and agencies, and indeed the difference between maybe some trying to say, okay, this is not actually a law enforcement purpose, we are not a law enforcement agency. The Act also covers a subsection on AI used in border management and security. So there are also a number of high-risk use cases, including full surveillance and identification of people at the borders, or for AI used for risk assessment in this area. So indeed, we've tried to be comprehensive, and also on the point that, yes, there will be probably a lot of still use cases, because the legislators, it was really not an easy process to agree, because many different views were there from different communities, and a balance was somehow aimed. But we, as also the Commission, have the right also and the obligation to review this list of high-risk use cases every year and further look into practical examples that we can also amend it over time. And for this, as I said, that's why we have also the advisory forum, scientific panels, and other bodies to help us, but also public consultation and other means. So we'll be really also looking forward to the input from all of you to help us further make the AI Act future-proof for all the challenges, but also effective on the ground.
Just for the attention of the moderator, I see Joe and I see Fatou, who are eagerly pushing for the floor, but moderator's choice.
You can, but quickly, please, Joe, because like we have then also.
Yes, I'll be extra quick. I just wanted to point out that what the AIS Act is doing in trying to impose things on border agencies and other stuff will be taken to court. That's my next prediction. It will, and most governments will say that that part of the AI Act can be ultra vires, because it is extending into areas which are outside the competence of the European Union, including Section 7 of Annex 2 of the AI Act, which deals to border agencies, which is very useful, but can be declared ultra vires. Thank you.
Thanks, Joe. Just maybe very quickly, from also because you mentioned Europol, I also think for us it would be very important. I mean, obviously our, let's say, main legal framework is Europol regulation, and the AI Act is a lex speciale, which will also apply if we are a provider or a deployer. But also there are a lot of, let's say, things we have already in place, because most of our processing activities are high-risk processing activities. That's just the nature of what we are doing here. This is just what I want to say. And then please, Tony, you are the next one with your question.
I'm sorry, I have a reaction on Joe. As my colleagues of the MOD and the MOJ aren't present here.
Okay, please then.
I don't think the Netherlands Border Patrol is the example he's looking for, as they are a police force. We are, in the Netherlands, not always quite accurate in organizing our governmental systems, but Border Patrol is a part, actually, of the MOJ, but the MOD is housing them. But they do have a police task, not just Border Patrol, but much larger. In the Police Act of the Netherlands, they are mentioned as a police force. So Border Patrol is also something that we do within the LED.
Thank you for this clarification. Then please, Tony.
Thank you very much, and thank you for the presentations. They were quite refreshing after the quantum, yesterday, because I was confused about it. No, seriously, you wanted a case that could open eyes, but there are already AI tools that are meant for the bad acting, for bad behavior or criminal behavior. They're nudifying AI tools. As you know, we can take a group photo and there's a tool that we can be all naked, just like that. And why I'm saying this, they already exist, those tools, and the AI Act, yes, it entered into force in August 24, but the rest of the provisions will act in years to come. So how to approach those things? And then we have another tool on tools that generate child abusive material. I'm talking about naked and raped children and so on. I work in the crime field of protecting kids, so that's why I'm asking those questions. And usually children are not in the front line of the discussion. It's always like mass surveillance and the cyber attacks and terrorism. So that's why I'm asking those things. So any ideas how to approach against those developers, IT companies and private companies, because now we are all focusing on law enforcement. We have to consider also what are the private companies delivering to the market, any kind of market, and can frighten our lives. So what to do with those and how to approach them according to how the AI Act will actually start fully in force in years to come. Thank you.
Thanks a lot, Tony.
Thank you very much, because indeed that's a concern, and we recognize it that a lot of those tools are can be already harmful and create those harms, or can be misused. So what we are trying to do in the AI office is also to launch an AI pact, which is to encourage companies and also other organizations to apply the AI Act already before the deadlines that we have. Because these deadlines, they come with the legislation. We can't impose and require all these strict requirements all of a sudden already now, but we're really encouraging companies to implement and pledge with real commitments the early implementation. And actually, we support a lot, even broader organizations, if they want to be part of this AI Pact community, to engage. If you look at our website and you search for AI Pact, everyone can subscribe, and we are going to have a big event already on the 25th of September, when more than 100 companies, we expect that they will make these pledges for early implementation of the AI Act as such. And for indeed some of those very harmful tools, what we are trying now with the future guidelines on the prohibition practices, I mentioned those that are most relevant here for the law enforcement area, but as I said, we also have this unacceptable social scoring, or we also have unacceptable exploitation of vulnerabilities of certain vulnerable people like children, or harmful manipulation of individuals. So with this, what we are looking is concrete applications that we could actually see already now, general purpose AI systems or others, and try to give them as examples, because these prohibitions will apply after 6 months now, on the 2nd of February, and we will try to really prevent those most harmful practices already now. And for the future rules as well, for general purpose AI models with systemic risk, have even additional safeguards, requiring the providers to implement safeguards already in the design of those tools.
Thanks a lot, Jadranka. You also want to respond? So we have 7 minutes left, so still we have then the question of Ayman, and then another one of you, but please just...
I want to thank you for the very relevant question. Also, we can mention here the Digital Service Act, which obliges platforms to actually take down and filter out illegal content, such as child pornography and revenge porn. But often in this debate, I think it's not sufficiently addressed the point of view of the victim. Because deepfakes are very hard, and also practical concerns. So deepfakes first are very hard to detect. So most of the people develop deepfake AI, while very small percentage of people work on actually detection. So we have actually a need for experts in this area. No, well, at least what as far as I know. We have sufficient deepfake detection experts. Okay, and from the point of view of the victim, that often it is very hard, and we need expertise to take down such content from all the platforms, because it keeps reappearing, even if already it is investigated and the perpetrator is maybe in jail. So taking down such content from platforms is another very important practical concern.
Thanks. I think you should also then further discuss this at the coffee break. I think, Tony, that's very important. That's also a good discussion, I'm sure. Then please, Ayman, to your question.
Thank you for the super interesting presentations. I just have a general question out of curiosity. We've already seen instances of the use of AI in law enforcement going horribly wrong. are there internal protocols in place already which ensure accountability in case something does go wrong in the future? For Europol, like, are there already procedures in place or accountability mechanisms?
Maybe I can take that. Yes. So although I think it's premature actually to say what compliance with the AI Act actually will look like, but already even before the AI Act, Europol has been engaged with academia and we have developed accountability mechanisms such as the accountability principles of AI framework that we have developed jointly with several Havel University. And in fact, the tool I mentioned before, CC4AI, it builds upon the knowledge actually we developed during this project. And of course, Europol operates within very robust actually liability framework like the Europol regulation. We also have strong data protection safeguards, cooperation with the EDPS and redress mechanisms. But of course, Europol is not an example actually of law enforcement. So we already had a strong ethos and all these, let's say, built in on our corporate ethos. But I only expect now with the AI Act we'll build new accountability frameworks, new procedures actually to further strengthen these. Of course, it's challenging. What I mentioned before, we don't know how what compliance with the AI Act will look like. We have the Commission, the AI Office that work on the guidance actually, and I hope that in 3 years we'll be here again and we'll see this from a different perspective.
Perfect. Thanks a lot, Damianos. We can also further discuss it then in the coffee break. I just want to give a big applause to you as a panelist. Also, thanks a lot for your great questions. And we will close the panel now, and we have then a break until at 10:30. At 10:30, we will start with the next panel. Thanks a lot.